So, contrary to what you are saying, we are not applying Article 50 to a situation pre-constitution. To a certain extent, you have to do that exercise. Otherwise, we will be coming to the conclusion that no pre-constitution institution can claim a constitutional right under Article 30. That's not the position. We can't say that a pre-constitution institution is not entitled to claim the right under Article 30 of the Constitution. Obviously, they are. So long as they satisfy two yardsticks, namely of being established by a minority and two, being administered by a minority. And now here, there is an issue because you're placing in issue the fact that this was really an institution which is established by the statute, according to you. That's what the preamble said.
They had other options of establishment.
That they need not have gone the statutory way. According to you, they could have followed the Vishwa Bharati route. You could have, or any other institution.
I'll not surrender my rights and claim their right after
you don't seek recognition of your degrees, in which case you could have just said, well, I'm going to be an institution which will be standing alone on my degrees, even if they are not recognized.
Stephen did
my students will not get government service, but so be it. Many other institutions did it. Stephens did it. Vishwa Bharati did it. That's one aspect of the matter. But does the fact that they really chose the statutory way, is that so destructive of their claim to minority status? Post-constitution.
Your lordships,
in which case we will be saying that once you accept the fact that you will be governed by a regulatory statute for the purpose of the conferment of degrees. It is a regulatory statute.
No, it's a substantive statute providing for substantive either power or lack of power.
But regulatory statutes are also substantive. They're not procedural.
There are three things, my lord, in this statute of 1920.
Does that completely destroy its claim of minority status?
Correct.
Or are these provisions which are designed to ensure the proper administration? Now, Governor General, let's take the case of the Governor General. You will find in a large number of institutions today, there is an approval required of a government officer, minister in charge of education. Are these really, in that sense, are they controlling influences? Or are they in the manner of an overall supervising influence to ensure that nothing drastic is done? We must also understand that the British government had sensitivities. They didn't want any one institution in India to become so powerful so as to affect the imperial dominion power.
No, they say otherwise.
They were not running these institutions.
I'll answer that.
This was all designed to ensure ultimately that no institution went out of the mainstream as they wanted it.
No, my lord, and some movements which were started doesn't spread across the nation. That was the reason, the movement of independence. And that was the reason why most of them said, no, we would prefer movement and not your...
Therefore, all the regulatory statutes were intended to provide one overarching objective. And that objective was nothing should be done to destroy the hegemony of the imperial government and the colonial power. Protect the colonial power.
Maybe as a general
and education is a very important source of, it's a source of cultural power. And we have seen it pre-independence and we have seen it post-independence.
May I answer your lordship's question? Lord, first of all, the establishment is a fact which is pre-independence, which cannot be wished away even after the independence. How it was established? Number one. Number two, in my most respectful but very emphatic submission, these are not regulatory provisions. These are substantive provisions, either conferring powers or not conferring powers. Number three, when we talk of administration, we never talk of administration in air. Administration is always a layered exercise. For example, administration of a court, let's say for a particular high court, there would be 5 registrar generals, registrars having different powers. They would be administering, but according to what? According to something which is decided by some higher authority. That higher authority would not be doing on day-to-day basis the administration. Thereafter, the administration would percolate. But ultimately, the controlling thing would be the statutes. Controlling thing would be, in case of a high court, the resolutions, the constitution, etc., passed by the competent authority who has the ultimate control. So, my lord, please, my lord, do not take these as mere regulatory provisions. These are substantive provisions either we confer these rights A, B, C, D. You are not supposed to do X, Y, Z. It's very clear. These are power conferring substantive provisions under the 1920 Act, not just regulating who will administer. They are not, my lord. Therefore, my lord, please see, my lord, page 4. Please see page 4, my lord. And establishment is a factum, whether I succeed or we succeed or other side succeeds. Establishment is a factum which has taken place in 1920. That cannot be wished away. What the British did may have been completely wrong, but it has happened, and majority of the institutions have chosen to ensure that that does not happen with them. They came after the constitution and said that now make us a university or deemed to be the university because we established ourselves. We established this institution. And we have maintained its independence. We are administering it without any outside interference. In this context, please see page 4, Lord, section 28. J, my lord, ground J. Both the ordinances and the statutes, my lord, these are the administrative governance documents. A will have some powers, B will have some powers, C will have some powers, and Pune will have some duties. Powers coupled with duty for everyone. That would be decided by ordinances and by the statutes. Correct, my lord? That's the administrative structure substantially provided as a substantive provision in the Act. Statute could not have been amended without approval of the Governor General in Council. The power in this regard was so wide that the Governor General in Council could reject the amendments proposed by the authority of the authorities of the university. The relevant provision are section 28(2)(c) and 33. Lord, please read this. No new statute means after the first statute which were made by the Imperial Council. No new statute or amendment or repeal of an existing statute shall have any validity until it has been submitted through the visiting board, Lord, completely non-Muslim visiting board, which may record its opinion thereon to the Governor General in Council, and mark this word, my lord, and has been approved by the latter, who may sanction, disallow, or remit it for further consideration.
Yes, Mr.
Yes. So, the governance document that registrar will do this, deputy registrar will do this, joint registrar will do this, court master will do this. I'm just giving a hypothetical example. And Pune will do this. That is the document. That governance document, which is the documents of administration, there is no power in the court, exclusive power with the court. The Governor General in Council would say that no, this is not acceptable. So, similar is the position with ordinance. No new ordinance or amendment or repeal of an existing ordinance shall have any validity until it has been submitted to the court and the visiting board, which may record its opinion to the Governor General in Council and has obtained the approval of the latter, who may sanction, disallow, or remit it for further consideration. My lord, the respectful submission is, as on 1920, it was neither established nor was being administered by the minority, and therefore their claim post-constitution would not sustain. Lord, I can say Mao, if would have remained Mao College, could have raised the claim after the constitution.
When he said Mao, I said, where does Mao come from?
No. MAO, my lord, I'm sorry, not
Yes.
not Mao Zedong. No, I'm sorry, my lord. Mohammedan Anglo
Yes.
Oriental College.
In a lighter sense.
Your lordships are right. That college could have raised, not could have, it could definitely have raised that we established it. We were administering it. We are a minority now post-constitution. Because before that constitution, there was no minority concepts. There were, all of us were subjects, Hindus, Muslims, Parsis, Sikhs, Jains, everyone. Now, we have been doing it. That's what, my lord, the Saint Stephen did. Saint Stephen did that, my lord. And
now we have seen this note on
now please
what is
see,
the next point?
Post-constitution, my lord, I have given the chart.
Which is that chart?
Lord, page 5. Page 5. post-constitution after taking into consideration all amendments. My lord, as it stands today, as AMU stands today, is there any administrative control? Because your lordships, it is not disputed that word and will have to be read as and only. Established and administered, not or. It's not their argument also. Now, my lord, chancellor need not be a Muslim under the new act. If de facto governor appoints him, doesn't make the legal difference. Lord, kindly see, my lord, if
How many chancellors have been non-Muslims actually in the case of the institute?
we have not examined, my lord, but possibly all were Muslims. That's the convention. I am on law. 23 or 25 so far. So, my lord, de facto status would not change the legal position. My lord, for example, Lord, suppose there had never been a lady attorney general. That doesn't mean that it has to be a man. It incidentally happened to be a man.
That argument may be slightly different. That argument.
But I'm giving the
that
example may be different.
That would be a correct argument.
Lord, example may be a different, my lord, example,
But when we are examining whether what has been the history in the past, whether administration can be only judged on the basis of what has happened and what has been actually after in last, how many, 1920 till we almost now going to be completing 100 years in another 3 years?
103 years, yes.
103
I'll
years.
just
We have
answer
complete-
that question.
Any time in the past where the chancellor, pro-vice chancellor, vice chancellor have been non-Muslims?
My lord, I'll check up and say, but not to my knowledge. Possibly they were Muslims.
And why is it then that governments, both before the advent of the
My lord, I'm told
constitution,
4 were non-Muslims, my lord. 4 were non-Muslims.